Can you sell stock in a trust after death? Whether you can sell stock in a trust after death generally depends on the specific terms and conditions of the trust, as well as the laws of the jurisdiction in which the trust was established and is being administered. If the trust agreement allows for the sale of stock, the trustee can sell the stock as directed by the trust. However, if the trust instrument does not explicitly allow for the sale of stock, the trustee may need to have court approval or beneficiary approval to make those sales. It depends on the document. Typically, after the death of a trust creator, also known as the grantor or settlor, the trust becomes irrevocable, meaning it can't be changed, and the assets in the trust, including stocks, are managed by a trustee according to the terms of the trust document. When a trust is used as an estate planning tool, it will often call for the trustee to transfer all the assets to the beneficiaries and then terminate the trust. However, in some cases, the trust is not meant to terminate, and the beneficiaries are simply to receive income from the trust. In this situation, the trustee has a fiduciary duty to manage the trust assets for the benefit of the beneficiaries, which may or may not include selling stock owned by the trust. It's important to note that different jurisdictions have different laws regarding trusts and their administration, so it's always best to consult with a trust attorney to determine the specific rules and procedures for selling stocks in a trust after the death of the creator. Can you transfer stock from a trust to a beneficiary? Yes, as a trustee, you can transfer stock from a trust to a beneficiary without selling it, as long as the terms of the trust allow you to do that. If the trust instrument allows for the transfer of stock to the Benny, then the trustee can transfer the stocks as directed by the trust document. In some cases, the trust document may establish conditions that must be met before the stock can be transferred, such as reaching a certain age or achieving a certain goal, like obtaining a college degree. If the trust document does not allow for the transfer of stock, then the trustee may need court approval to transfer the stock to a beneficiary. How do you transfer inherited stock from a trust? The process for transferring inherited stock from a trust to a beneficiary depends on the terms of the trust and the laws of the jurisdiction in which the trust was established and under which it's being administered. Before transferring stock from a trust, the trustee should review the trust instrument to determine if the trust allows for what they're anticipating and what conditions, if any, must be met before the stock can be transferred. If the trust agreement allows for the transfer of stock, the trustee should follow the steps outlined in the trust document to transfer the stocks according to those terms. What if beneficiaries dispute the trust distribution of stock? The first step in resolving a dispute over trust distributions should be to review the trust document to determine the terms of distribution and what applies to any specific asset. In some instances, the trust instrument may specifically state how the stock should be divided amongst the beneficiaries. Even if this information is not explicit, the document might detail the level of authority and discretion the trustee has in making distributions. Often, trustees have a great deal of discretion when administering a trust. However, trustees also have a fiduciary duty to act in the beneficiary's best interests and abide by the terms of the trust. If the trustee makes a distribution that violates the terms of the trust or another fiduciary duty, the beneficiaries may be able to seek legal recourse against that trustee for that breach. But if the distribution was made according to the trust's instructions, then there's likely little that the beneficiary is going to be able to do about it. If the beneficiaries dispute the distribution of stock from a trust, it's important for all parties involved to discuss the situation with a probate litigation attorney. A knowledgeable probate litigation lawyer can help the parties understand their rights and obligations under the trust document and the law and decide the next best steps forward. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com. Thanks for watching.